Atlanta, a prominent conservative law professor, Stephen Calabrese, and one of his former students recently published a proposal to expand the federal judiciary by creating hundreds of new judgeships. A founder and chairman of the Federalist Society, of which I have been a member since 1984, Professor Calabrese promoted his judgeship bill as a way of undoing President Barack Obama's judicial legacy. But there is nothing conservative or otherwise meritorious about this proposal. Professor Calabrese, who teaches at Northwestern University, argues that federal courts are overwhelmed by their caseloads. He complains that appellate courts hear too few oral arguments and issue too many unpublished opinions, and that district courts too rarely conduct jury trials and approve too many plea bargains in criminal cases. He also contends that the Federal Judicial Conference, the policy-making body for the federal courts, opposes more judgeships because it fears an expansion would diminish the prestige of the judiciary. None of this is true. Professor Calabrese writes as if the judiciary should perform its work as it did when he served as a law clerk in the 1980s for 2 appellate judges and for Justice Antonin Scalia. But the federal docket and court processes have changed a lot since then, often because of changes championed by conservatives. Today, courts use unpublished opinions to issue quick, reasoned decisions in routine cases based on settled precedent. For example, thousands of petitions to review deportations and denials of Social Security benefits turn on discrete facts determined by administrative law judges. Hearing oral arguments and issuing published opinions in most would only delay decisions that should be speedy. In criminal cases, sentencing guidelines adopted during the Reagan administration and laws establishing mandatory minimum sentences encouraged defendants to waive jury trials and to accept plea bargains offered by prosecutors. Reforms passed by Congress in the 1990s made it easier for courts to curtail abusive habeas petitions challenging state convictions and to dismiss often meritless prisoner and pro-se filings. And even before the 1980s, it made little sense for federal courts to publish opinions in those civil cases where they must follow state judicial precedents. Many of Professor Calabrese's ideas lack common sense. For example, he says that my court, the 11th Circuit in Atlanta, optimally should have 56 judges, even though we expeditiously administer our current caseload with 12 judges. He contends that the 4th Circuit in Richmond, Virginia, should have 57 judges, the 5th Circuit in New Orleans, 53, and the 9th Circuit in San Francisco, 79. No appellate court could operate on that scale. Judges who must decide appeals collegially would barely know one another. Jumbo appellate courts would be unmanageable. Professor Calabrese's proposal also fails to account for the hundreds of senior, or semi-retired, judges who shoulder a large part of the judiciary's workload. Expanding the number of judges as his plan calls for would leave scores of federal judges with little more than a part-time job.